Once you're ready, I'll go live. Order, order. Welcome to this session of the Justice Committee, continuing our evidence on our inquiry into the probate service. Welcome to our panel of witnesses. Very grateful to all of you for coming to assist us today. We very briefly have to deal with declarations of interested members. I'm a non-practising barrister, former consultant to a law firm.
I'm a barrister with a current practising certificate but not undertaking any direct court work. I'm a former Solicitor General, former chair of CAFCAS, former chair of the National Child Safeguarding Practice Review Panel, and my brother is chair of the Prison Reform Trust. I'm also advising ministers on family justice policy.
Right. Anything else? Okay. Shall we start from the right-hand side then? Just introduce yourselves and your organisation, please. Sophie.
Yeah, sure. So I'm Sophie Wales, Director of Regulatory Policy at the Institute of Chartered Accountants in England and Wales, and we are an authorised regulator for probate.
I'm Stephen Ward. I'm Director of Strategy and External Relations at the Council for Licensed Conveyancers. We are the specialist regulator of specialised conveyancing and probate practices.
I'm Ian Bond. I'm the former chair of the Law Society Wills and Equity Committee and also a partner at Irwin Mitchell.
I'm Mark Wally, CEO at STEP, the Society of Trust and Estates Practitioners.
Thank you very much. I know all of your organisation, I think yourselves, individually on their behalf, have submitted written evidence to us, for which I'm very grateful. We've had all of that. Obviously, sometimes things develop after we've had the initial call from evidence. And we've certainly had some feedback that initially, when we had all the evidence come in around January time onwards, your organisations were pretty negative about the performance of the probate registry. Now, some of the information we have now is that there has been an improvement. How much and to whatever degree we'd be interested to know, really. So I just wonder, would the suggestion that's put to us that the registry's improvement has improved in recent months chime with you and your members' experience, and if so, to what extent or not? Mark, you want to go first?
Yes, the experience has improved, but from a very low base.
Yeah.
So we're nowhere near the service that used to be available. Yeah. But we recognise improvement. We're concerned about sustainability of improvement.
That was the other point. And what causes you to be concerned about the sustainability?
We surveyed well over 100 members, or well over 100 members responded. So we've got a very big base to look at this. And they're still seeing cases that are taking well over the average time, right, and might be 9 months or more. Yeah. And a service where you can't submit an inquiry for 4 months, 16 weeks. I can't think of another service where I can't find out an answer for 4 months.
Okay.
It's ridiculous.
Is there anything, I mean, we'll come on to the detail, what would make you think that the improvement was sustainable? Is there anything?
Well, there's a little bit for me that I used to be a retail banker, and so used to deal with probate loan requests and all the associated details more than 30 years ago. And back then, if we had a loan outstanding for more than a month, something had gone horribly wrong. Fast forward, and we're now talking about 4 months just to ask a question about a submission, and potentially 9 or more months to actually get something done. It doesn't feel like progress.
Okay. Let's come down the other way this time. Here.
I think for the Law Society, yes, we have seen improvements, but we still feel it's very much fragile. We've had 6 months' worth of data where they've issued more grants than they've received in applications, but that's on the back of 5 quarters, but being the opposite way around. And so we are concerned that saying, yes, they've turned things around, but it's still fragile, and we haven't seen it's yet to be sort of issued as this will be sustainable for the long term.
You want 5 quarters or so going the right way before you... Yeah, okay. That's it.
And I think we would echo that. And we haven't surveyed our regulated community again in the past few months, But I think the key point to pick up on is that the averages and the improvements belie some of the longer periods that we see for certain cases that can be extremely drawn out. So I think we need to take that into account as well. It's not just the overall sort of average that we see improving, and we also share the concerns about the fragility of these improvements and whether they're truly sustainable. The proof of the pudding will be in the eating, won't it?
Yeah, and I think very similar from us. So I think we would see that there's been some improvement, but only in the last couple of months, really. But it's very unpredictable. So I think firms said to us, well, we sent one in and it came back very quickly in a matter of weeks, but a similar one, it's gone into the ether and it could be months. So firms don't want to yet say to their clients, it's improved and you'll get it more quickly, because they just don't know and you can't manage expectations.
Yeah, no, okay, fair. Again, a common feature of all the submissions that you helpfully sent us was concern that they don't have enough staff to be able to deliver the level of service that would be reasonably expected. And I was just looking at the background, you could see 300 odd sort of say in about 2005-6, and then I gather there was a restructure of their operating model in 2008, which caused a reduction in staff, and you can see that if you look at a sort of graph, and then it drifts down to a low level in about 2017, as I see it, and then maybe since, unless I'm wrong, since about 2021 or so, 2022, you see an increase in staffing again. So rather more in 22, 23, and then an increase into 24. Has those increases in staff, which we've seen the raw data seem to be there, has that played through in terms of the experience that you and your members and their clients are getting, I suppose is the question.
In a mixed way. So we can't dispute the numbers, they're what they are. The quality of experience is still very mixed, and it really depends on who happens to pick up the case or answer a query. There are ranges of competence and experience in those numbers, yes. And I think if you looked at the numbers and found out how many people have been there for X, Y, or Z period, I'm not sure it would paint quite such a rosy picture.
Right, no, fair. I wasn't aware that you hadn't seen the numbers, Mark. I've got the figures from the Ministry of Justice's evidence to us,
okay.
And I can tell you what they are to see if that helps. What they're saying is that from the restructure in 2008, there was a reduction from a level of around 300 down to 153 at the start of the reform project in 2017. If that makes sense, and what they now say, let me quote the whole lot to you and see what you make of it. Alongside the lead-in time to train new staff on the probate process, this lower baseline level of staff limited the resilience of the service to meet changes in demand. Well, they seem to accept that. And they're now saying that they're holding staffing levels at around 280 full-time equivalents. So that's what they're saying.
Just to say, I've seen the numbers and we've read that. The difficulty is the fact of saying, as Mark was saying, you've gone from having almost 300 staff who have got 20 years worth of experience, reduce those down, and those 300 equivalent staff now have 20 weeks experience. And putting lots of new staff in at one point in time means you take away the staff that do have the knowledge, because they've got to come away from issuing grants of probate, and then they are training the staff, and so it makes things go backwards in the initial phases. So it is a case of saying, yes, it's good that they've got staff, but the quality of the staff, the experience of the staff is what matters, and the decimation of all the experienced staff leaving the registries around the country has had this impact. The fact of saying they don't have the quality and experience of staff anymore to deal with some of the complex applications.
And is that the real problem, as far as you're concerned, that centralisation?
Nothing wrong with centralisation. Probate service is a service that can be done from anywhere. So centralisation isn't the problem, but is letting those experienced staff go. And we all now know from the experience of COVID that you can work pretty much anywhere on an application. They didn't have to be aligned to a buildings, but when the registry buildings around the country were closed, the sites were closed, those staff left and went redeployed in other areas, magistrates' courts or whatever it is.
Right. Is that because, in fact, physically they were trying to centralise it?
We previously used
Birmingham.
different registries up and down the country. Probate registries, sub-registries, you had a transport registry, there were 30 different sites. There's not 30 sites now. There is a big CTSC centre, the contact centre in Birmingham. Those people, those numbers in Birmingham aren't the same people who work in the registry.
No, indeed.
The person from Plymouth has got no incentive to come up all the way up to Birmingham.
No, which would be pretty obvious, you'd think, to any organisation that's doing a restructuring. Mark, did you any more observations once you've got those numbers?
No. I was content with the numbers. It's exactly the point of experience within those numbers.
I mean, some of you, maybe yourself, Ian, or Stephen, or Sophie, some of your members would have spoken to the staff at the time that the regional centres were closing down. What were they saying about why they weren't going to move to Birmingham or whatever, or where they were going to go, what options they were given? Can you remember? Yeah, good.
Just in terms of they are employees of HCTS, and they want to remain employed, so they would just redeploy into the magistrates, the family courts, or whatever it was, because there are centres up and down the country for the courts and tribunal services. And so if their role in the probate was coming to an end and they didn't want to relocate, they would just take another opportunity within the service. To a certain extent, as you know, with the civil service, they will have grades. They're at a grade, they transfer across within the organisation. That's what they did. So that was lost. Those people stayed within HMCTF by and large, but that experience in probate was lost.
It wasn't realistic for many of them to move, so they're going to take an equivalent job where they are. Okay. Stephen, any other points around the staffing levels and the
Well, I only say it's not a numbers game, as colleagues here have said. It is about experience and so on. But we see parallel problems in the Office for Legal Complaints, for example, where they've sort of, it feels as though they've fished out the pond of available talent, also in Birmingham. So there could be an argument for decentralisation in that respect, having access to more staff. But I think at this stage we're not going to get those experienced staff back. And so really it's about looking to the future and how do you build up that experience and how do you make sure that it's retained as there's churn within the organisation.
We're going to come on to that experience point in a second, but again, if Sophie and others you may pick up, the only point I was going to ask as well is HMCTS said to us that they're now providing a more resilient resourcing model, says MOJ, and part of what they're saying is that to do that they've introduced a system where staff can be temporarily moved from other services to the probate registry to address spikes in demand. I suppose is the point, well, yeah, but they're not going to know much about the work of the probate registry when they're temporarily moved there.
And I think that's really part of the bigger issue, isn't it? Because clearly a lot of knowledge walked out the door when those experienced staff left. And a computer system has not replicated that knowledge. It might help with sort of allocating cases or whatever, but it doesn't have that knowledge. So I think there is that gap, and it will take time to build it up again. And it's good that they're trying to do that, but I don't think, that a HMCTS employee is not homogenous. You can't just take one from one place and put them in another if they don't have the skills and knowledge. And I think that's borne out by our firms say, well, it's really hard for them to know whether there are still pockets of that good knowledge because they wait up to an hour for a call to be answered. The person they speak to probably doesn't know the answer, probably can't help them. It might be there's somebody somewhere else who does know, but that's not who they're talking to.
Okay. Great. That's very helpful. Ms. Hopkins.
Thank you. Just pushing a bit on that knowledge and experience that is so vital we're hearing. What would you regard as like that sufficient level of qualification or experience that you'd expect to see for staff to be able to process applications efficiently and well? Anybody?
There's a certain level of it is experience in the service, just doing numbers, going through the different processes. Now, with the work and the way it's allocated with CTSC, different members of staff get trained on different parts of the application. Previously, all staff knew all applications because when the piece of paper dropped through the letterbox, back in the old-fashioned ways, that was your piece of work, you did it. So you had to know whatever came in through, you had to know the process to get it through, to get it to a state where you can give it to a registrar to sign off and say that grant can be issued. Now with the different allocations, so different people can have different areas that they specialise in perhaps, then they can see that certain grants will go through quicker than others, and certain members of staff go, I've opened it, I've looked at this application, it's not within my remit, I close it, I put it down, I put it back in the queue. That's wasted their time, and it's not progressed the matter. So they all have to have a minimum level of staff so that they can issue all the applications that are there. They can do with all the types of work. If not, they have to make sure that they can allocate the work to the people who have the skills to do it. And then when they know what types of work they've got coming in and they know the numbers, they've got to have the number of people to do it. Because at the moment, the complex work which is going to the registrar, they don't have enough to get that through the door, whereas they've got a lot of staff that can do the simple and straightforward things.
Given that was a very thorough answer, do others agree, or would you like to add anything?
Yeah, to me, it's like triage at A&E. You know, see somebody who knows where to send you.
Yeah.
Sorry.
I was just going to say, so I think I agree with what's been said, but I think there need to be more registrars, because my understanding is that there are very small numbers of those nationally, which has got to be a bottleneck.
Yep.
And I was only going to say that I think this is one of the arguments in favour of seconding in some experienced probate practitioners who could do some knowledge transfer to some of those staff in HMCTS, perhaps.
You mentioned complex cases, and HMCTS have given us sort of the two examples of the types of cases it considers to be complex, which is when the deceased are living abroad and where the original will is missing. Do you agree? Are you satisfied that they are complex cases and therefore they should take a bit longer to process?
Those two examples would be complex cases that you could add to the list. So multiple properties,
Right.
just as a start point. I'm sure my colleagues could keep adding to the list, but it's not just a two-stop shop. And why does it have to take longer? Because it's complex. Give it to somebody who's appropriately qualified, and they might be able to do it in a similar time. Yes.
That goes back to the point you were talking about earlier about people leaving.
Now there are some very complex cases that, of course, they'll take a little bit longer to work through.
Yeah.
They're going to become more complex, we think, as life becomes more complex, families are more complicated, the way people want to hand on their possessions becomes less straightforward.
Yeah, thank you.
And I think from my organisation's perspective, my members' perspective, the very nature of the types of clients they're dealing with makes most of their cases complex.
Yeah, because that's why they've gone to estate planning practitioners.
Indeed.
Not straightforward.
I mean, if we could just say, at the moment, 80% of applications go online. They are deemed as simple. Paper applications are deemed as complex. Paper applications aren't complex, all by nature. So power of attorney applications are on paper, trust corporation applications are on paper. They are not complex at all, but they have been put into that categorisation. So they get delayed because they're on paper and the paper is taking longer. There's less people looking at them. So there has to be a move away from sort of saying paper is complex. It's saying complexity, as they say. The only things that are really complex are jurisdiction matters, foreign domiciles, the assets abroad, a will that's written in French, those sorts of things, or the fact saying there's documentation that's missing, damaged, and that's the thing, saying that's the true complexity. But the current system of paper being equated as complex masks that problem.
I'm going to push this question out as a bit of a flip, just to test everything, because we want to scrutinise and value your input. So obviously you're representing, professional people, very qualified. Person on the street might say, shouldn't they be able to complete the application on behalf of clients without relying on advice from probate registry staff? And could the reason for some of these complaints about the new system be partly because under the old system, with very experienced practitioners, they were relying too much on those registrars?
I think it's about stakeholder management. So if you've got a complex case, there might be a number of nuances, and picking up the telephone and speaking to the person who's going to look at it, to pre-position what's coming in so they know what to expect, and to talk through, this is what I'm seeing and this is how I believe it should be handled, feels like a really good thing to do. I mean, I can't imagine that you wouldn't go into I can't think of a type of meeting I'd go into where I wouldn't have spoken to stakeholders beforehand. And to me, it's the same. It's a complex case. So I'm sure others have got views.
I would agree. I mean, part of this is collaboration. We want to. we've got a set of rules. So I'll give you an example. For me, last week over Mitchell had a complex matter which I wanted to put through and talk through, saying the rules, I understand the rules, this is how I want to do it. There is some ambiguity in the rules, I can do it a different way. But what I don't want to do is put it in on paper because of the nature of the application, wait till it gets stopped. I want to have a conversation with someone to say, this is what I'm doing. I want you to give me some input. You will know and expect it. We'll agree this is the way forward, because I want this grant to be issued as quickly as possible, because I've got a grieving family and I've got a whole loved one behind this, and it doesn't matter if I'm right or the registrar's right. We work together to get that family that grant of probate. I'm not here for one-upmanship about does the registrar know more than me or do I know more than the registrar. The family is the important thing here. The family is being let down because I can't speak to the registrar and say, this is the way I want to do it. Is this right? I'm not going in saying, I don't know what I'm doing, please help me. And that is not what the reason why we want to speak to registrars and talk about our applications. We do a lot of education of our members across the board of how to put the applications through. And that is not what we're talking to registrars for.
And ultimately, it is the prerogative of HMCTS to determine how certain applications are done. So, I mean, to the point made there in terms of you could do your best guess and you could do what you think is appropriate, and then you don't hear anything for several months, only to be told that that's not how they wanted it, and you've got to start it again, which is not great. But also there are some grey areas. So it's better for everybody concerned and a more efficient probate process if you can discuss it, come to an agreement, and then everyone thinks it's the right way to go.
And if I said that the shift has gone from being a relational process to a transactional process, would that be a fair reflection?
Yeah, the collaboration has gone.
Yeah, okay, thank you.
That's encapsulates it well, thank you. You're right, Sophie, you mentioned there weren't very many registrars. I think for the record, STEPS evidence says that there are now 2.6 full-time equivalent as opposed to 30. So
For the country, yeah.
For the country, indeed, for England and Wales, yeah. So that's great. Dr. Mullen.
Thank you. Just building on the questions from my colleague, you've talked about examples where there's a genuine grey area, and I don't think anyone would argue that that's a matter of a lack of knowledge on the behalf of the practitioner. But are you saying that there's never a time when you haven't heard of a case or had a colleague who's done it in a certain way, and you look and think, well, that was just the wrong way to do it, and that wasn't good practice, and that this does in fact give some examples of where perhaps the service before prevented that to your benefit?
I would say yes, there are. Not every application can be perfect. And there will be ones that there are issues. And this comes back to we want to have communication between all these organisations and HMCTS, because through the probate user group, they give us information about what are the stops, what are the things that we're getting wrong, what are the common issues. Then we go out, and I've done webinars and seminars, I've written articles and blogs, and we all do that to all our members, saying this is how we improve. If you give us data, you give us the information, then you share the information with us, we share that with our members. Every application goes in and the feedback is to that one applicant, whichever the profession is, and we never learn. So planes, they have a black box. You crash the plane, the black box is listened to, that is disseminated amongst the whole industry. Everyone learns, everyone gets better. The data and the sharing of the information, the collaboration between all these organisations on this panel and HMCTS, the communications between us, if it was better, we would make sure that our members did better applications. So work with us, we'll make them better. We're not perfect, but we could be better with the information they give us.
And there was, I think, previously a consultation, a proposal that didn't progress, that would say actually if you want advice, so pre-lodgement advice, that you potentially would be charged a fee for that. If there was a reform of the fee structure, so there was a flat fee, lower flat fee, but those that did actually have a contact, you would have to pay. What would your response be to that idea?
Yeah. If they're providing a service, we will pay for the service. And that will then sort of say, do I genuinely need to do this pre-lodgement inquiry? Because ultimately our fees, the fees are paid by the clients, and therefore it may drive up quality and standards in the industry. Ultimately, if there is one that's really naughty and we want to get it right, we will pay for that service, and that service will cover its own costs. So whether it's whatever number it is, it will be proportionate to the time the registrar is spending with us. And so it's not that that they will lose funds from doing it.
Yeah.
They will gain funds.
Yeah. Do the other representatives think about that idea?
Sorry, I was just going to underline there that that's acceptable, but I think what we would like to see from the probate registry side at the same time would be that improvement in output about information and advice and guidance, because together we can make those improvements and make the whole system more efficient, reduce the numbers of questions that there might be, reduce the numbers of stops. But that is going to require probate registry to be a bit more porous, if I might put it like that.
And I think I would agree that if it was not a massive additional fee, I'm sure people would much rather pay a bit more and know that it was going to be done smoothly. But I think we have to make sure we don't forget that a lot of people do this themselves as consumers. So you would still need to make sure that there was a route for those people to get help without extra cost, because that, I think, would deter people from getting the help they need to do this.
Then I guess if they choose to do that and they've not pulled it off as such, then they're the one who has to wait longer. That's their choice.
Yeah.
It is a choice. An alternative option might be of having a complex estates team, rather than it just landing in.
So separate fee.
Well, a team within a team. Most organisations have people that deal with basic stuff and people that deal with more complex stuff.
Which is whether as Ms. Hopkins alluded to, has this lack of expertise in-house shown that perhaps there's to some extent a lack of expertise or effective practitioners on the other side? Two things happening here.
As Ian said, it would be remiss of us to suggest that every application that went in was perfect. I mean, it's just not the real world. But it feels wrong to suggest that if there are a handful of cases that weren't great, that therefore the blame's on us. But the answer is share the information with us. Tell us what's stopping things being processed, and we can collaboratively as organisations with all of our members get that message out really, really quickly. Because what we're set up to do.
I think if you're the registry, I think ultimately it doesn't actually cause them a harm, financial or otherwise, to have some people waiting a long time. There's no consequence to them. The consequence is all meted by the applicants.
Yeah.
And so if there's a fee that they can only charge if they're providing a good service, it perhaps creates incentives on their end too to live up to a higher standard on some of the complexity of the case if they want those fees.
And I think to pick up on the point that Ian made, it's almost as if we're forgetting that there are grieving families that are waiting for answers and can't settle bills, and they're getting into financial hardship.
Yes.
And perhaps blaming their advisor for the delays because they don't understand. And so we're getting that feedback from our members saying, well, they're taking it from the client who thinks it's their fault, and they're going, well, it's just stuck in a queue.
Okay. Perhaps another way in which we might address this issue, and we've touched on it very briefly already, is a suggestion from STEP and the Council for Licensed Conveyancers that you might bring in more third-party support to tackle this bulge of difficulty that we're still in, or actually more generally as a way of doing this. I don't know if anyone in particularly supports that proposal and why. I wanted to begin by commenting.
Well, I suppose we were one of the respondents who put it forward. We think there's a lot of expertise out there in the marketplace that could be brought to bear to help get the backlog down, to build that resilience that I think we're all a little bit worried about how robust is the system, improving, but is it robust? And some knowledge transfer there from very experienced probate practitioners to perhaps newer HMCTS staff who are in the probate registry. So we think it's something that's worth looking at. We have something of a parallel in a way, in the way that we appoint intervention agents when we close down a law firm, and those intervention agents then carry on the transactions that were live in that law firm. So we have some experience of managing in a similar process.
You're a dedicated team of people who do that for you, or you have?
We have a panel
of
of
law firms. Yeah. Okay.
So whilst I could see there might be concerns, it seems like a potentially very good way to eat into that backlog and build some more resilience, because if the backlog doesn't continue to be tackled, then come another spike, we could see problems escalating quite quickly again.
Okay.
So, and from STEP's perspective, we had the same view, very much that we see this as a temporary solution. And so, you know, get a panel together for the benefit of the end client, the practitioners, and the service. Everybody wins out of this. But it does feel like a short-term solution to a backlog, not something that carries on forever.
Do you think, in terms of value for money, I don't know if you've looked at the pay scales and grades for the civil servants that are working on this at the minute compared to what your members might charge to come and give some advice?
Made that comparison. I'm not sure what the rates of pay are for the particular civil servants working in the probate registry. It may be more expensive, or it may be that a deal could be reached, but it still has a great potential, I think, for tackling that short-term problem.
Similarly,
Couldn't answer. I don't know what
I think the baseline salary for someone working there is £22,000.
But it's you're comparing qualified professionals with government employees, and we all know that private sector pays more than public sector to do the same job, and we're not comparing the same job.
Okay. I mean, the counter argument to doing this might be that actually, as we've all talked about, the issue here is a loss of learning, and over time that's going to, you would hope, gradually be returned. Is coming up with a whole other way of doing things, even on a temporary basis. It's obviously going to take up, management time, and we've all talked about, and evidence points to the fact that actually they need to be focusing on other things and getting the job done rather than having to organise this whole new way of working with the sector.
I think there's probably a way, though, that you could structure it so that a proportion of the staff went and worked with an experienced, knowledgeable practitioner, so that there was that knowledge transfer. I think it's really important that it wouldn't just be outsourcing completely so that somebody is doing the work and the staff don't learn. I think it has to be very much teach a man to fish rather than give him the fish, because that solves the problem today, but it doesn't solve it going forward, does it? So you could see it conceivably be designed so that a third of the staff do this on rotation, and the other 2/3 are processing things, and you could cover that off in a fairly short period. You'd have thought maybe a year.
Almost like little training courses.
Yeah.
Okay. And Stephen, in particular, I think in your evidence you touched on a similar exercise that had been undertaken in the home selling and buying sector that the Council for Licensed Conveyancers have been involved in. Anything you could learn from that? Does that ring any bell?
That didn't relate to this particular issue. That wasn't around capacity, for example, the land registry. But I suppose it's worth saying at this stage that there are parallels in the land registry in terms of tackling a backlog and having lost some experienced staff, and how that is being dealt with, how that's being tackled. So it may be that Probate Registry could talk to Land Registry about how they're going about rebuilding that expertise in the organisation.
I think that, again, didn't that involve the profession as well, and the companies taking part in that? It wasn't just the Land Registry on its own doing it.
Well, we've got, I would say that the Land Registry is a very good model for how the Probate Registry could be more engaged with the sector. I think that would be the lesson I would draw across there, and that's about the knowledge sharing, understanding what's going wrong in applications that are going to the Land Registry and communicating that back to the sector so that everybody learns and the whole process becomes more efficient, as we'd like to achieve in this field too.
At the minute, is there none of that doesn't happen at all at the minute? There isn't any kind of strategic engagement with the sector about, well, this last few months, these were the 5 things that were causing us issues. There's none of that, or it should just happen more.
We have the Probate Practitioners User Group, so we meet regularly. We've been meeting regularly since 2018 when the issues started coming out.
Do they come to that meeting?
HMCTS come to the meeting. We have the organisations here, other organisations, charities who's had evidence from previously. We have regular meetings every 6 to 8 weeks, feedback going both directions, and that's where some of the things that have come out of those meetings, where we've done, as I said, webinars, seminars, blogs, articles, things that we've disseminated to the profession in order to, as things are changing. Now, they've had changes to their phone service recently, and they discussed that with us before they did that, and they sought our opinions as organisations, and partway through that we had a sort of take stock. How has that worked? Will it continue? Now, this has got a lot better recently because it's being more collaboration between us, and the communication has worked a lot better. Initially in 2018, when we started having these meetings, it was very much a them and us frosty reception, and it was blame being thrown across, and we've had to work hard to get this, and we've had some success. There's been changes of management structures at HMCTS, new personnel coming in, and it's engaging with them. And I've been fortunate to be right the way through all of that time in all of those meetings to actually see this is how we've engaged with them, and we are trying to help as professionals to get us into a service that works for us to get the grants. All we want is our grant of probate to be issued, and we want it to be done quickly.
Okay, thank you.
Thank you, Mr. Stimson.
Thank you, Chair. On average, about 50% of deaths lead to probate application, and in 2023 we saw the second highest ever number of probate applications, 302,363, which you will know is behind just 2006. I'm sure you were all diligently working in this field back then with all the experience that you have. But that also puts added pressure on the probate registry, and the forecast is that by 2030 there'll be over 700,000 deaths per year, and of course people are living longer. So that would be, if my maths is correct, about 350,000 applications, so significant uplift from where we are and the struggle that we've already heard about the backlog. You've already intimated some of the ways that they could help tackle the capacity restrictions that there currently are within the registry. But from the conversations you've had and from the evidence that you are on the receiving end of, how well do you think the probate registry, HMCTS, are alive to and prepared for those challenges that will inevitably face them over the next 10 to 15 years?
They do their forecasting, and they've been very clear that they're doing forecasting, so they're aware of the statistics, the increase in deaths. The one thing we haven't talked about is part of the reason we are here is because the opportunities to modernise the service has just focused on, if we digitise everything, if we put everything online, we'll all be happy. What we haven't done is we haven't looked at the black letter law, we haven't looked at the probate rules that set it all out and actually say, what is the things that we can do to those rules? Because the black letter law is the Senior Courts Act 1984. The non-contentious probate rules, which govern everything we do, is 1987. They are 30 years old, and when, if I can indulge 30 seconds just to go back and say, 2008, 2009, there was a working party to look at the rules to say they weren't fit for purpose. The probate rules is the only part of the court service which, like the civil procedure rules and the things that you're familiar with, practice directions, modern language, very clear processes, everything was set out. Probate was left behind, so we're left with Latin terms, we're left with affidavits, oaths, we're left with two-track systems, one for citizens, one for professionals. We had two sets of different fees. We were left behind. 2009, we recognised that. We had a working party. 2013, it produced a set of rules that were designed to get rid of all the Latin, get rid of all the issues that we had. It was a consultation put out and then stopped. 2016 didn't build on that. It just says we'll digitise the old 1987 rules, and they lost all of that. So we are then trying to say to them, you can't digitise a process when the black letter law says that physical will has to arrive in the registry. That grant that's come from abroad that is being asked to be resealed has got to be a physical grant in the registrar's hands. All of these things weren't looked at. All of this paperwork is required by the probate rules to be put in, and therefore if you're digitising something, you have a paper handoff. It can't ever be fully digitised with the rules that stand, and no one took into account the fact of saying the rules need to change. Now you're asking about what goes forward. The Wills Act is 1837. The Law Commission are looking at a new wills bill next year. They're going to be talking about things not just about our wills that we've been having for 180 years. They'll be talking about digital wills, video wills, wills made by a text message, wills made by email. The probate rules as we stand at the moment will not cope with that. And we need to have some serious looking at those rules before we do anything. And so, 300,000 extra deaths with this new set of legislation that's coming out from the Law Commission, without something happening to the probate registry, they will fall over when these new rules come into play, because Nothing written in 1987 prepared us for video wills, for email wills, for text messages, and all the things that the Law Commission are going to bring in for us. And so there needs to be a serious amount of work. They need to collaborate with every single person on this panel and bring those rules up to date.
Quite a lot of nodding going on. Is that a shared view? Does anyone else have their own take on it?
Nothing to add. That's
the issue around registrars, and we've heard some of the figures earlier, and the call, I think it was from Sophie, about that may be one of the solutions. Could you just expand on just a little bit more about how you think in the new world that the registry needs to work within in order to meet the demand that we placed on it, that the role that registrars could play to help them navigate their way through that?
Yeah, well, I mean, I think a lot of what's been said in terms of what wills might look like in the future is a big issue here, but also the need for will writing to be regulated so that there's a better quality of wills that are coming in the first place, because I think having a poorly drafted will causes problems. So I think it's kind of coming at it from both perspectives. So I think it's making sure the wills that are produced are of a good quality and make sense, so that they come in, and then that you have a registrar or more registrars who are familiar with all the types of wills. So it feels like there's a few steps to go down.
Is there another jurisdiction that any of you are aware of that have already gone through this process of moving from the analogue to the digital, whilst also recognising that the laws that underpin it need to be revised and modernised in order for it to function correctly? Is there anywhere that we as a committee should be looking at as not necessarily a full blueprint, but at least a way of demonstrating the art of the possible?
I mean, in terms of, if you look at other jurisdictions, just by the very nature, so Australia, New Zealand, Canada, South Africa, they all took the basis of their legislation, our wills and our probate, when they became independent, and they've taken them and done interesting and wonderful things with them. The Law Commission went and had a look at those for will writing and their probate registries, so you can admit a digital will, so a will via email in Australia, you've had wills via text message, you've had unsent text messages, so other jurisdictions have had the ability to use what was the basis of our probate rules to their probate registries, but giving the registrars discretion. And this is back to changing those rules. So those rules, the issue with registrars is the rules written in 1987 basically said everything's got to go to a registrar to look at. Not everything, if you look at those rules, not everything requires a registrar. So you can actually look at those and actually say the registrars need to look at this. This is the stuff they need to look at. This other stuff, which at the moment they look at, because that's what the rule said in 1987, you can handle that down and you can get some suitable qualified staff to do those bits and issue those grants. So you look at those rules again and say, really, what do they need to see? The top people look at the top things, and then you triage it down. And that's where the rules need to be looked at and changed. Giving judicial discretion or registrars discretion is what other jurisdictions have done, and they are Commonwealth jurisdictions, so they'll be very familiar to you and easy to look at.
I'd add to that of our members, 2/3 of them are outside the UK, and we can go and ask those questions. Ian's given some examples, but I'm very happy to go and ask for examples and then write back with some suggestions for you.
Thank you very much.
Okay.
Stephen.
If I may add as well, I think it's very, very important that we don't forget that this is not just the legal sector. There's a financial sector that needs to be brought in here as well. We've got to see joined up thinking across those two parts so that we make the best use of the tools that are available to us now that weren't in the 80s. Are we making the best use of open banking technology? Are there new ways to use it that might be brought out? So I think we've got to bring not just the people here, but people from the financial services as well to think about how would we build it now? Not how do we, we made the classic mistake of digitising a system that wasn't perfect, and we need to think about how we can change that.
Okay, we've just been told we've got potentially 5 votes coming. Each one takes a quarter of an hour, very shortly, so we may need to.
I will just very briefly add a couple of questions, if I may. Key to achieving that will be improved communication, which we've already spoken about during this session. But part of that includes looking at, as some professionals who've submitted evidence to this committee have suggested, is the introduction of minimum service level standards for the probate registry. Now, this could be a sort of double-edged sword, in as much as it could set out something which they can be judged against. It's more transparent, but it also potentially carries the risk of essentially being displacement activity that doesn't really resolve the underlying problem. So first of all, is this something that you and or your members would support, and if so, how should it be instituted so that it's successful and helpful? Ian?
The Law Society's position is we've for the last 5 years said there should be a minimum service level. So yeah, if a client comes to us and asks us to do something, we don't do it, there are consequences. Your colleague said there is no consequences if the probate registry takes 16, 18, 20 weeks. So if there was something like a fee remission, so if a grant didn't get issued within a set time, or if there was an issue that wasn't an issue, so it was erroneously stopped, you would have a part refund of your fee. That works both ways in terms of service level. If the application from the practitioner doesn't come in and doesn't hit the standard and it gets rejected because it hasn't hit the standard, you take example from registering lasting powers of attorney for the Office of the Public Guardian. If an application is rejected, it gets sent back to you and says, do it again, and you've got to pay half the fee again to get it redone because you haven't done it right first time. So the probate registry it works both ways. If we hold you to account as the probate registry, you don't deliver the grant as you say you would, we get a reduction. If we put a rubbish application in that gets rejected and we get told to do it again, we pay again for doing that, and we would have to pay that, not our clients. So it can work in both ways on that part. So it's not just us trying to say, here's a big whip to beat the probate registry with. If they don't deliver in 16 weeks, we want our money back. It's actually saying raise all standards.
And I think there's a holistic approach you could take. So I think there's 4 main areas I'd say you'd cover in minimum service standards. So you'd come up with what are some realistic processing times for different types of applications and publish those so that people know what to expect. There should be a minimum number of, maximum number of working days in which you should be able to get a response to a question. And it wouldn't necessarily have to be a substantive response if it required more thought, perhaps. But to say, I don't know, within 10 working days, somebody from the probate office will respond to your query. And practitioners I've spoken to have said it could be any number, actually, as long as it is a number that they know that they will get a response, and it's not, how long is a piece of string. I think there needs to be the ability, once the application is being processed, that you can speak to the person who is dealing with your case. And if that needs to be by appointment, then I think people would accept that. But at the moment, I just think there's that blocker there, and the communication isn't getting through. And lastly, as people have said, the ability to talk to somebody within the first 16 weeks. 4 months is a really long time for you to have to say to a grieving family member, I don't know, not a clue, can't help you. And even if it was just, it's been accepted and it's been allocated to somebody and you'll have contact in however long. So I think there's some quite simple things that could be done that would make a massive difference to managing expectations of users of the service.
To HMCTS, I'm told that they have trialled surgeries where practitioners who stop cases have been with them for longer than 16 weeks can request a 20-minute appointment with a registrar or experienced probate manager. First of all, is that the case? And secondly, what feedback have you had from people who've accessed that service?
I mean, it is the case. Last week I was at Newcastle Probate Registry and we discussed those surgeries. They had 90 surgeries. Of the 90 surgeries which were booked, they were booked very quickly. It's like a Take That concert. As soon as tickets come up, they go. But when those appointments were then created, they found that they could actually issue 35 of the grants before the appointments took place and be able to reopen those and bring other practitioners in, because actually what they did is saying there was an allotted time to speak to a practitioner about a case. Because there's an appointment, the registrar looked at the application and goes, actually, I've got everything I need here to issue the grant. I don't need to have this. I'm just going to issue it and I'm going to reopen that elsewhere. Those surgeries will work. And that's, it was a trial basis, and the feedback is, yes, that's brilliant, do more. Because when I phone up and ask you a question, the first thing you've got to do is find me on the system, you've got to kill time, you've got to then read the bits and pieces. That's not a constructive conversation because you're on the back foot because I've called you. Whereas the registrar has got a dedicated time to call out that practitioner. They've read the papers and they go, right, Ian, this is your issue, this is what I need from you, do that and I'll issue you a grant. Can you do that? Yeah, okay. Can you send it to me via an email now? Yes, okay, I'll issue it as soon as I get your email. That's what the surgeries are there for, to clear out those issues. Proactive, on the front foot, collaborate with the person who's put the application in. Don't be afraid of us. We'll get that grant issued.
Thank you.
Thank you. The top.
Thank you. Just a bit of a quick one, thinking about processing and information. Lots of respondents, including the Law Society, responded and said they wanted to see more transparency and improvements to data sharing and data collection and data sharing. So what difference would more transparency and more timely information from HMCTS make?
If we take an example from the Land Registry gives an awful lot of data, different types of applications, different organisations, which organisations do the most, which organisations do the least. You remember from your evidence from Jo, she says we do about 6 applications a year, but they are usually the most complex for people with hundreds of millions of pounds and assets all over the world. That then goes up against other organisations. So Owen Mitchell, we would probably be comfortably in the top 5 of the number of applications we put in. You'd be able to have transparent data about which organisations do the most, which organisations have the most stops. Again, if there's an organisation that puts in 100 applications, but 50 of those are stopped, as a member of the public, as a consumer, you can look at that data and go, I'm not going to use them. It drives up standards. And that data is a goldmine. The charities talk to you about all the things that they could find out about it. As professionals, as representative bodies, we'll be able to find out an awful lot of data. And be able to talk to our members, which firms do the most, what type of applications are they good at. Consumers will be able to make an informed choice rather than just on price or recommendation. They'll be able to see, yes, I'm an expert, I do thousands of these as an organisation each year, I know what I'm talking about, use us. And that's what the Land Registry do, that's what the Probate Registry could do.
And I think historically our members love the probate service. They couldn't say enough good things about it. And the reason they want data is so that they can work together to restore that position. And there's almost a sense that, we don't want to release data because we're going to get beaten up. It's no, we just want to help and to have some transparency.
Any other?
As a regulator, I would really like that information about stops, because we use the information we get from the Land Registry as one of the risk criteria as we look at firms in the round to understand how frequently we should visit them and inspect them and encourage them and so on. So having that sort of information, that's the kind of thing I was really talking about when I talked about Probate Registry becoming more porous, just being very transparent about that sort of thing, because all of that sort of data nowadays can be used in all sorts of different ways by all sorts of different parties to improve access, to improve outcomes for the citizen. Lord.
And actually, I think from our perspective, data that gives a fuller picture of what's going on in terms of timescales would be really beneficial so that you can manage expectations, because saying this is the average doesn't really help somebody who's right up here or right down here. And the evidence that we collected said actually the biggest harm that clients were facing was emotional and psychological and frustration. So actually, if you could say, this is the picture and this is where you sit in the overall piece, I think that would help.
Thank you.
Thanks very much. Just looking at the regulatory situation, I noticed actually this morning, very timely, the Competition and Markets Authority has launched a draft consultation on draft consumer protection law compliance guidance for unregulated businesses, providing will writing, online divorce, prepaid probate services, etc. So some of the areas that we're interested in. Against that background and the previous history, which I think you're all familiar with around the regulatory landscape, is the framework around reserved activities on probate, will writing, estates admin broadly correct, or should there be changes, do you think?
That's a very big question.
Yeah.
I mean, the Law Society have its stated positions of which we could send into you
That's
and all
right,
these things.
yeah.
But the fact is of saying that it was looked at 2013, I believe.
Yes, indeed.
And the decision was made and it said, OK, there was evidence of consumer detriment. As organisations, we have to do more for public legal education. Now, all the organisations across here have done a lot to educate our members and a lot to educate the public. Is it time to look back at it again? Potentially, because there are still harms. And in the moment, there are bad actors, nefarious companies that are coming in and exploiting. People are scared, they see probate delays in the papers, and they get offered a product that say we can avoid you having to get probate. And as always with these things in life, if it looks too good to be true, then it probably is. There's all sorts of unintended consequences that go with it. But there are vulnerable people out there who are wanting to say, I don't want to have my family sort of waiting 16 weeks to get hold of a probate to get access to my funds. They may be rightly or wrongly concerned about inheritance tax. Yeah. All these things that are there, that there are bad actors in the industry that will prey on those vulnerable people to then say, well, I can solve all of that for you. Let's go down these. Now, some prepaid probate is one thing, but there are others that are selling all sorts of products that are there that all the organisations here will tell you have had consequences where they go wrong, they go spectacularly wrong, and the consumers are very badly hit from that perspective.
And the bad actors have no professional insurance either.
No, indeed.
There's no safety net.
Should we revisit that 2013 LSB inquiry into those areas?
The CLC thinks certainly yes. We were very disappointed and surprised about the decision back in 2013, and as ICAW has just said, one of the drivers of some of the challenges in probate are bad wills, badly written wills. So we need to address that at the very beginning, but also the wider issue of estate administration. People are dealing with this at a very difficult time in their lives. They are, by definition, vulnerable clients, and we think this is a classic area for regulation to protect those vulnerable.
So adding those areas to reserved activities, basically.
Absolutely. It seems very odd that you have to be regulated to do the probate but not to write the will. It's the most important document you're ever going to have written for you, really. Bar a few others. So it's a bit odd that anybody can write that for you, and the harm that causes, and what the firms tell us are, actually, if a firm then has to step in after someone's death and deal with a poorly drafted will, it ends up costing the family more than if it had just been paid for and done properly in the first place. So there is a real mismatch that I think needs to be addressed.
If you need to get away any time, do let me know. Yes, Mr.
On that final point, I mean, it's absolutely right that anyone can write the wills, but that cost will put off some people. But should there be a cap on that cost in terms of writing wills? Because at the moment, someone can charge £50, others can charge £300, and then there'll be others that will then exploit the vulnerable to say, this is how much it's going to cost you. So if it's regulated, then there needs to be a cap in terms of what needs to be charged.
Well, I think it's about giving consumers choice. I think if you made it so they were aware of all the providers and they had transparency over the pricing, then the competition should mean that it brings the prices down. But I don't. Yeah. I think paying a very small amount for a bad service and a bad document is not in the interest of consumers.
Just very quickly, I guess the thing that's slightly different about this dynamic compared to, say, home sales, etc., is you can just do your own will. So that's why I think it's a bit more complicated than that, because you could just imagine a whole load of people who at the minute might be getting some advice, might not be good, might be okay, would then just be getting any advice. So you might create a worse situation unintentionally.
Yeah, I think you have to get the right balance, don't you? So you've got to think about how can you bring in regulation that passes on the minimum of costs to the consumers so that they're not deterred from getting professional advice. But I think it's a bit Wild West out there at the minute.
Okay. Thanks. Mr. Simpson.
Thank you, Chair. We talked before about the projects to digitalise and centralise the work of the Probate Office, but and I'm sort of looking specifically at Ian, but others are very welcome to comment if they wish to, about prior to that, this probate modernisation project, which I believe you had some involvement in. Could you say a little bit about what that was, what it hoped to achieve, and whether it did achieve anything that we should take note of?
Okay, so the Working Party was set up 2009. It's set up to look at the probate rules. It then formed a working party. It had members, organisations here, judiciary. It had registrars. It produced a set of rules, modernised rules that were based very much on the civil procedure rules. In the same practice, took out all the arcane language, the different types of Latin that we use, the different types of grants. It took out the different processes between citizen and professional. It looked at what documents should and shouldn't be sort of sent in, and it produced that draft set of rules. It went out for consultation. The consultation closed. No outcome was ever published. It was never taken anywhere. So that piece of work, and we can write to the clerks and let you have that. It still sits up on the various different sort of websites for the judiciary with the draft set there. That was the basis. The whole point of that was to modernise the probate service, and it is a service, not a place, and it could have used that as the basis of saying, right, there's the draft set of rules, put those in place, then we digitise those because they were designed to digitise. They were designed for a modern world. If you did them again now, you would take them even further because we've learnt a lot more from COVID. But we didn't. They were just shelved. So when we were sitting having the meetings in 2016, I'm attending those meetings in 2016, it's a case of then saying, no, we'll just digitise what we've got. And it's a case of saying, well, this is backwards. You're asking for oaths and you're asking for affidavits and nothing has been updated. So you're just making things far more complex. You need to sort of look back at this point of view. And of course, it's the profession being painted by HMCTS as being, we're backwards, we want to keep things as they are. We didn't. The registrars, those who were there at the time, were saying, no, we need to look at the rules first before you digitise things. And the management consultants that came in, the original set of staff that were dealing with this, that got taken off the projects, pretty quick afterwards, soon realised they couldn't do what they set out to do. Setting everything online, one process, we like that, but you've got to change the rules to do that. The black letter law applied, and they didn't do anything about that.
That was a missed opportunity.
Absolutely.
And it's all been done the wrong way around.
I mean, at the moment, the project was opened in 2016. It was supposed to finish in 2019. Project has been closed. It's not fully digitised. It's 80% there. The project's been closed. There's no money for it. There isn't any plan of how they're going to get the last bits done. Throwing good money after bad. And it's a case of saying they made an expensive mistake from decisions that were made not by the current management system. They're just picking up the pieces of what was decisions that were made badly beforehand. They've made an expensive mistake. Let's not throw more money after it. We just recognise we did it wrong. Get the Law Commission in, redo the rules, get them ready for 700,000 deaths, get them ready for a new set of will rules, get them ready for a modern world, and then digitise and get it right. Otherwise, you're just going to, we're going to just pump more money into it, and we're going to fall over another point, and you'll have another committee sessions in a couple of years' time. Hopefully, I won't be here at that stage, but it'll be a case of saying what went wrong. We tried to, keep on a 1987 set of rules to make, make a modern world fit onto that.
And if someone was to, and hopefully someone in a position of power was to pick up the baton of the rules that you wrote quite well over a decade ago now, how long do you think it would take for them to integrate themselves into a new sort of probate system? It's maybe very difficult to put a specific figure on that, but we don't want to scare the horses.
No, I don't think I could say about how it would fit into the digitisation. In terms of those rules, they're there, they're online, they were drafted. To pick them up and have another review, you could get a working committee through, you could get your registrars from Newcastle, except we want them issuing grants, but you can get senior judiciary, you can get people from all these organisations, you can get stakeholders, you can get members of the public who are interested to actually say, how does this work for us? What have we learned from the COVID years? What have we learned from the intervening periods of time? Let's work together, collaborate, get something that's usable for the future, because we're tinkering around the edges with a set of rules that from 1987, and we've fluffed them around here, we've fluffed them around there, but we need to actually come in and say, proper look at this. Just like the Law Commission are doing an absolute generational change for wills, you need to then have the probate service, which is the natural follow-on from that wills legislation. That has to be looked at with the same gravity and the same importance. Otherwise, we're going to have some very shiny new legislation for wills, and no one's going to grant probate.
And there's a lot of free resource as well in the legal and financial sectors that will help crack this and make sure that we're taking advantage of all of those changes that we've seen, particularly driven by the pandemic and what we learned to do through remote working and the way things were speeded up. Also, there are hundreds of startups out there champing at the bit to introduce new tools, but not to old processes. They give us great new opportunities of different ways of working that are better for the consumer, the citizen, and would make the land registry's job much easier and more resilient for those 700,000 deaths, do you say?
Thank you very much.
Sure. Thank you. It's been very helpful, everyone. I just wanted, finally, perhaps just to wrap up the various thoughts that we've pulled together and the written evidence that you've given to us. You've highlighted that the reforms, or the intended reforms, have caused significant problems. I think that's putting it mildly, perhaps. What's the key lessons? What's the key takeaways, do you think, that there should be for us as a committee and for HMCTS? Are they simply for the probate service? Is there broader application that might be suitable?
I suppose I've got sort of three closing thoughts, and one is you need to address the short-term problem, which is around sort of upskilling the staff and getting the interventions to try and get things out. The second one is making it fit for the future with the minimum service standards.
Yeah.
And the third one is what can you do to mitigate some of the financial damage that's been caused to people who've suffered from the delays. And I think there's things you could do around sort of interest on inheritance tax instalments. There's things you could do around extending how long you've got to get loss relief on share sales. Happy to send the committee more details of our thoughts on that.
Yes, you can. Yeah. If there's any further thoughts from this, do please send them through. Steve?
At the risk of sounding like a broken record, harness the industries who are doing this work to build it for the future in a way that's going to be effective, and really take that forward. Listen and make sure that the probate registry is providing the information that will inform that process too.
Yeah.
I think just to echo everything, this has been a good learning process for HMCTS. Part of it is how not to do a project. But the thing is, they have to take away, they need to communicate, they need to collaborate with those who have got a stake in this, whether it's the public, the consumers, it's the industry bodies, and the online probate service is a good idea. The whole process, the idea behind it is right, the execution is poor.
Yeah.
It's not the people who are there now, it's not their fault. They're just trying to make good some decisions that were made previously that they're picking up on. But with better collaboration between us as professionals and the industry, well-designed, well-thought-out processes, standardisation, service level agreements, transparency both ways, us upping our game, the probate registry knowing what they're going to receive from us, and better communications all round will mean that we can get through this issue. And I think there have been lessons learned. They won't make this same mistake again with other areas. It's just a sad thing that it had to happen with probate.
Yeah, indeed so. Well, look, I'm very grateful to you all for your time, and we dispatched actually a lot of material very efficiently, and we have just about beaten the bell literally, because the Minister is winding up the debate before we have the votes. So grateful for your time today. Thanks for all the evidence you've put in before. And if there is any additional material you want to put in, then that's very gratefully received. So the session is concluded. Order, order.
The proceeding has ended. The proceeding has ended. The proceeding has ended. The proceeding has ended.